Welcome to Kibbe on Liberty. Get your notebooks out because we're going back to school with law professor Randy Barnett, and we're going to talk about some of the most important cases in our constitutional history. Check it out. Professor Barnett, thanks for joining us.
Well, thanks for having me in this very hospitable studio you have here.
It's designed to be the sort of the anti-Fox News. There's not going to be any flashing lights or shooting rockets.
But I know from previous times is that if it rains out, you have to scrub the interview because you can hear it on the roof.
Yes, my Christmas project is to finish putting the insulation in the roof because we were going to do this almost a month ago.
More than a month ago, yeah.
And it was pouring rain, and you could not have heard us speaking right now. So a very professional operation we have going on here. But tell us, you're a professor of law at Georgetown University, and as far as I've known as a person involved in legislation and ideas and libertarian philosophy, you've always been sort of the guy to go to for a libertarian legal interpretation of not just the Constitution, but whatever it is we're fighting about. Why don't you give people a little bit of background on who you are and what you've been up to?
Sure. I grew up in Calumet City, Illinois, which is south of Chicago, and decided when I was 10 years old I wanted to be a lawyer. When I was in college at Northwestern, I came across libertarianism because a junior professor there gave a talk at the college, this residential college I was living at, and I thought, oh, wow, this sounds very interesting. And I met with him privately several times. And by the time I was a senior, I actually taught an accredited seminar, student-organized seminar on libertarianism. And then I went to law school. I went to Harvard Law School. And there I was got introduced to Murray Rothbard and the Libertarians in New York, and actually became a member of the Center for Libertarian Studies there in New York, and spent a lot of time in New York, more time than I should have given my studies at Harvard Law.
Yeah.
And after that, I graduated and became a criminal lawyer, which is what I went to law school to become, and was a criminal prosecutor in Chicago, trying for the Cook County State's Attorney's Office, trying felonies, murders, rapes, armed robberies, jury trials. That's what I did. And when I became a law professor, dealing with the Constitution was the farthest thing from my mind. I really wanted to work mainly up on what the proper theory of rights should be, private law. So I started out as a contracts professor. Also would be interested in torts and other areas that basically define what our rights are. What's the right you have? What's the right I have? When have I violated your rights? And then I got, for a long story I won't go into, dragged into con law somewhat reluctantly, maybe about 30 years ago. And now it basically occupies all my time. So I'm now 100% a con law lawyer. I still have a contracts casebook. I'll teach contracts every once in a while, but my scholarship is all about the Constitution. And it didn't start off this way, but around the late 1990s, I became attracted to what's called originalism, and that is interpreting the Constitution according to its original public meaning. By 1999, I had published a piece about this, and my book in 2004, Restoring the Lost Constitution, was all about originalism, why it was the best approach to interpreting the Constitution, and what did the original meaning of the Constitution say.
Well, let's jump right into that, because I think I've been sweating bullets because I felt like I was back in class, sort of studying up for this interview. And hopefully there's not a test at the end of this. But I've been talking about the Constitution more from a philosophical understanding of what individualism is and what individual sovereignty at least should be about, and even the founding influences of Madison and Mason and all of the guys that developed these ideas. You can go back to the Scottish Enlightenment and perhaps even further. But you have a new book out called An Introduction to Constitution Law with your colleague Josh Blackman. And this is...
But the subtitle is key
to... 100 Supreme Court Cases Everyone Should Know.
That could have been the title.
Yeah.
But for marketing purposes in law schools, it had to be the other title. Yeah. But it's 100 Supreme Court Cases Everyone Should Know.
And before we dive into this, let's talk a little bit about the 2 or 3 books that sort of you've written that lead us up to this, because this is case law. This is not philosophy.
Exactly. So my first book on the Constitution Restoring the Lost Constitution, the Presumption of Liberty was about how you should interpret a written Constitution, original meaning, and what is the original meaning of key provisions of the Constitution. So what does the Constitution say? Presumably courts should follow that. The second book, Our Republican Constitution, which came out just a few years ago in 2016, that was about the role of judges. It wasn't about the original meaning of the Constitution. It's what is the role of judges in a constitutional republic in enforcing the Constitution. And there, that was responding to my experience in the healthcare challenge, which I was the lawyer that originally devised the argument for why the individual insurance mandate was unconstitutional, and I ultimately became a lawyer for the National Federation of Independent Business when it went to the Supreme Court. What we learned in that case was getting 5 votes that your theory of the Constitution is right is not enough if one of those justices, in this case it was the Chief Justice, decided that his judicial role told him that he needed to defer to Congress. Well, he wasn't saying what the law was. He was saying what his role as a judge was. So I wrote Our Republican Constitution in response to my experience with the Obamacare case, and that's how the book starts, with my experience, as to why he was wrong about the role of the judges, and he was not alone, why conservatives have actually been wrong about the role of judges for a very long time, and why we need a more active involvement or engaged judiciary to invalidate laws when they really are unconstitutional, stand up to the other branches. So that was my second book. Now this is a book that's not about those things. This is a book about what has the Supreme Court actually said about the Constitution. That's what we call constitutional law. Constitutional law is not the same thing as the Constitution. Constitutional law is the law that the courts will follow and that the other branches presumably also follow because the courts follow it, of how you implement the Constitution. And so what's the best way of learning that? That's what I teach. This morning I finished my last session of Constitutional Law 2, which is about rights. In the fall, I will teach Constitutional Law 1, which is about structure. But what I'm teaching in those classes is not the original meaning of the Constitution. I mention it. I talk about it. I'm teaching what is the law that we now live under that the Supreme Court has given us. So what is the best way of learning that? There's lots of ways to learn it, and they're fine. But what I think the best way to learn it is as a story, because I think constitutional lawyers and justices have a story in their head about what has happened from the founding until today and where they fit into that story. And this story has characters, like all good stories do. It has justices or characters and other people, but amongst the characters are these cases, each one of which is a story in itself. And if you go back to the beginning and you come back through today, you tell the story of constitutional law by telling the story of these cases, each one of which is a riveting story. And then you see that there are the good cases that you're supposed to emulate. These are, we call the canonical cases, the canon. And then there's the bad cases that you're supposed to shun and not be like, and we call those the anti-canonical cases, the anti-canon. And it's easier to even spot the anti-canon cases like Dred Scott and Plessy versus Ferguson, the good cases like Brown versus Board of Education. So what the justices and lawyers are carrying around in their heads, even if they picked it up indirectly, is a story about who are the heroes and who are the villains in this saga. And you want your case to conform to the good guys, the heroes, and you want to avoid the bad guys, the villains. You want to paint the other side as they're basically pursuing the bad cases, the villains. And so the best way to tell the story is as a story, and that's what we do in this book. And we do it, as we're going to talk about it. We do it not only by means of the chapters of the book, but each chapter represents a separate video that Josh and I spent 2 years producing in a TV studio up in Chantilly, Virginia. We spent 80 hours in the studio over a 2-year period with the scripts in front of a green screen, recording our narration of all these stories, and then in post-production, Josh, my co-author, is primarily responsible for all the graphics and the illustrations and the pictures and the animations and the excerpts from oral arguments and the excerpts from the hand-down statements that the justices, when they deliver their opinion, they deliver it in court. And we have excerpts of the recordings where they are explaining the opinion themselves. All of that is there to tell these stories in as engaging a manner as possible and as accessible as possible for the average law student, college student, high school student, and member of the general public.
Yes, this is the book itself is a very consumable product, because I think chapters tend to be 3 or 4 pages long a piece, and it gives you a snapshot of the history. It gives you the argument that's happening at the time. And your concept for a law professor at Georgetown University, you actually want to make law and constitutional law accessible to actual people.
Well, and I consider my students to be actual people, and
well, they're not people until they become lawyers, and
right.
Then
Well, they're halfway in between. They're quasi actual people, quasi lawyers at this point. But I was up in front of them this morning, and then I had our exam is next week, so I had 6 or 8 of them in my office, sitting on the floor, asking me questions today, and they're no different than anybody else. Matt, you could take this course, and for one thing, it's all new to them. They may have taken other courses, but they haven't taken this course, and so this story is new to them.
Yeah.
And I think it's best understood as a story. And once I started teaching this way, all of a sudden the exam performances started to go way, way up, and we got everybody along. People got it better or worse, but even the people at the bottom of the class basically get the story.
It's funny that you use storytelling, because that's the whole reason of what we do at Free the People, is that we're trying to explain ideas, and in our case, more about economics than law, in the context of a often personal story, maybe a historical story as well. And our theory is that that's more interesting to people than economics. God help us, as an economist.
Well, my last book, Our Republican Constitution, I turned the manuscript in. It had been accepted, my first trade book, accepted by HarperCollins. I was having celebratory dinner with my editor in New York, and thinking, oh, this is great. I'm done. They gave me a nice advance. And then he says over dinner, it's not accessible enough. And I was like crestfallen, like I did the best I could. I wrote the whole book. You already accepted it. Like, what am I going to do now? And I said, what does it need? And he says, it needs more stories.
Yeah.
So basically I said, well, I can do that. And I went and found a story of they're all different kinds of stories, like, the Revolutionary War story or other sorts of stories, or even my own stories about arguing the medical marijuana case in the Supreme Court. So every chapter starts with a story to illustrate what's going to happen after that. He was satisfied that we'd really hit the mark. But the other thing that was interesting is I actually, in finding these stories, learned stuff about what the subject of the chapter was that I didn't know before I found the story. I had to read a book about the Declaration of Independence, because that was what I'm going to talk about. And I learned stuff about the Declaration that turned out to be really significant for understanding the proper theory of government that we have in this country. Anyway, it turns out I think I'm going to always try to write this way from now on. I think stories are the way people learn.
Yeah. Well, let's go through this, and then I want to get back to distribution and potential audience for this. But consulting with you, my professor for the day, I think we're going to tell a story about the journey of the original founding concept of individual sovereignty versus the power of the state, and how that's been this ping pong ball, depending on who's interpreting what, and what the politics of the day are, and ultimately how they dealt with the contradiction of slavery and all of that stuff. But let's start with Chapter 1, Chisolm versus Georgia. And this is...
Well, I can tell what it's about if that's what you want. If that's what you're looking for.
Well, how do you want to do this? Let's talk just briefly about what it's about. But what are they arguing about?
Right now, Chisolm versus Georgia is the first case. One of the questions we get is, what are the cases in this that you talk about that were a surprise or that people wouldn't expect?
Yeah.
Well, Chisolm is one of them, because Chisolm is a case that we think is really important, but actually isn't normally taught in constitutional law. It's taught in federal courts for reasons I don't need to go into, but it's hardly even mentioned in constitutional law. The reason why is because it gets reversed by the 11th Amendment, which is the amendment that comes right after what we call the Bill of Rights. The 11th Amendment reverses Chisolm versus Georgia, so why study it today if it went away?
Yeah.
Well, there's a good reason for it, and that is that the Supreme Court in that case considered the most fundamental principles of political theory in our country, and that is the nature of sovereignty and the nature of the relationship between the people and the state. And these were extremely long philosophical disquisitions by these justices. There were 5 justices. And the facts of the case are that this particular individual had sold Revolutionary War supplies to the state of Georgia. He lived in South Carolina, and he sold Revolutionary War supplies to the state of Georgia. The state of Georgia didn't pay for them. So he sues them in federal court for breach of contract. And Georgia says to the Supreme Court, you don't have jurisdiction over me, and so we don't even show up. Georgia doesn't even show up in the Supreme Court. And the reason why it looked like he could sue the state of Georgia was there's a provision in the Constitution which basically says, it really seems to say on its face, that the Supreme Court has jurisdiction to hear suits between states and citizens of another state. Well, he was a citizen of another state. Georgia was a state. Under the plain meaning of the Constitution, it really seems like he ought to be able to sue. Well, what did Georgia say? Georgia said, oh no, we have sovereign immunity. And this may sound a contemporary note.
Yeah.
We have immunity. We are immunity as sovereigns. You can't haul us into federal court. We're sovereign. Well, what did the Supreme Court say about that? And this was Chisholm's case was argued by Attorney General Edmund Randolph in a private capacity. What did the Supreme Court say about that? By a vote of 4-1, because there were 5 justices on the court, by a vote of 4-1, they said, oh no, you can sue the state of Georgia. And they only relied secondarily on the text. The text was there. They relied primarily on first principles. And the first principle was this: the people are the sovereign of this country, and the governments are merely the servants of the people. And there's no reason why the servants of the people cannot be hauled into court to answer to their sovereign, their masters. So the people are the masters, and the government are their servants, and the master can take the servants for exceeding the authority given to them under whatever constitutional provision we're talking about. And they not only said that, but remember, the individual was suing was just an individual person. And at least 2 opinions, quite starkly, this is the opinion by James Wilson, who was a principal founder from Philadelphia, one of the principal authors of the Constitution, and John Jay, who was the first Chief Justice and also one of the co-authors of the Federalist Papers, the early authors. These 2 guys both referred to individual sovereignty. What Wilson says is that in the Constitution, the word sovereignty never even appears, because the people, they said, might have presumed to call themselves sovereign, but in the preamble, let's say, but they avoided the ostentatious declaration, he said, because that would have been even presumptuous. But so they goes through all the meanings of sovereignty, and basically sovereignty essentially resides in the individual. He says the ultimate sovereign is the individual person, and that's why an individual person can take even a collective body like the state of Georgia, the legislature state of Georgia, to court. This was a very fundamental decision, 4-1. Now, it was very unpopular. And the reason it was unpopular is the states did not want to be subjected to all of these lawsuits. And in particular, they had a complaint, they had a beef. And their beef was, we were promised when we entered into this Constitution and abandoned the Articles of Confederation, that the federal government would take responsibility for all our Revolutionary War debts. Now we're in. And now you're telling us that we have to be sued by private individuals for these Revolutionary War debts that you said that you were going to assume. They felt they'd been snookered. And as a result, they proposed and in 2 years enacted the 11th Amendment, which basically negates the ruling of Chisolm and says you cannot, that the Article 3 shall not be construed to allow for a suit by citizen of another state to a state. The state cannot be sued that way. However, here's the thing. It doesn't repudiate the ruling in Chisolm about popular sovereignty. It merely negates the outcome of Chisolm. And we don't think it repudiates popular sovereignty, but subsequent Supreme Courts, 100 years later, after the Civil War, the Supreme Court from that day until this day says, no, the principle of Chisolm was repudiated by the 11th Amendment, and we deny that. We think the outcome was, but not the principle, and the principle is as valid today as it was then. Now, that's how the book starts, with that story. And how many pages is that chapter?
And
It's like 3 pages.
Yeah, 2.5, really.
Right, and then there'll be a video that illustrates all of this and has pictures and everything.
Yeah, and there's a video that corresponds with every chapter.
Exactly.
And it gives some context, and you can see the illustrations and the quotes and all that cool stuff, which again tells the story. And what I get out of a lot of these stories is basically the inherent politicization of a lot of these decisions. It's a political decision that's going to hold together the new Constitution. It has nothing to do with what the Constitution itself literally says.
Well, it has something to do with it.
Yeah.
I mean, the courts never really, let's put it this way. The courts never expressly disclaim their obligation to follow the written Constitution. You will not get a justice during his confirmation hearings or on the bench who says, you know what the Constitution says? Fine. We don't have to follow that. We have a better idea. They never say that.
Yeah.
They have all kinds of intricate ways of finding ambiguity or vagueness or we're not sure, but they never say they don't have to follow it if they actually agree this is what it says. So I think we have to be clear that as bad as many of these Supreme Court decisions we write about are, they don't go that far.
Yeah, yeah. But when you talk about originalism, you're talking about that core concept.
Yeah, the original meaning. What meaning did it communicate to the general public at the time it was enacted? That's what we're talking about. And the courts will oftentimes avoid that.
Yeah. In sometimes hilariously tortured ways.
Yes. But they never say we have a right to disregard it.
I didn't know that women, for instance, were so delicate because their blood was thinner than men.
Yeah. Well, that was we're skipping ahead here, but that was actually a very famous brief filed in the Supreme Court by progressive hero Louis Brandeis.
Well, we'll go back to that because I just disrupted our study plan.
Right. Okay.
But that's one that stuck with me because it's so patently ridiculous, and even at the time it would have been, I think, ridiculous. But
it was science, man.
The science is settled.
It's science. Yeah. You can't deny science.
Okay, we're going to jump forward.
That is, an underlying sub-theme of the whole story is junk science is used all the time to reach bad results.
Yeah, particularly in the progressive area.
Right.
Prigg versus Pennsylvania, 1842. What's that one about?
Another case that I wouldn't expect people who watch this know anything about. It's about something really fundamental, the constitutionality of the Fugitive Slave Act passed by Congress in the 1790s to implement what's called the Fugitive Slave Clause of Article 4 of the Constitution, which gives slave owners the right to recapture slaves. They say they will be surrendered up upon demand. That's what the Constitution says. And then in order to implement that, the first Congress or the second Congress passed the Fugitive Slave Act, which created certain procedures for enforcing the Fugitive Slave Clause. So anti-slavery folks, which I've become a big fan of and have written a lot about, anti-slavery folks like Salmon Chase, who ended up being the Chief Justice of the United States, who followed Roger Taney, the author of Dred Scott, appointed by Abraham Lincoln. Chase, when he was a young man, in Cincinnati, developed an argument in defending runaway slaves that the Fugitive Slave Act was unconstitutional because there was no enumerated power in the Constitution to enforce Article 4 of the Fugitive Slave Clause. And then he said, if you look at other provisions of Article 4, you'll see, for example, in the full faith and credit provision, which says states must grant full faith and credit, there's a specific power that's given Congress to implement that. And there's other provisions in Article 4 where there is a congressional power given, but there is no congressional power given to enforce the Fugitive Slave Clause. So therefore, he said, what that clause was, and the rest of Article 4 was what he called a comity clause or a treaty. Essentially, that was a clause that was a treaty that bounded states, but they essentially had to honor that treaty or face repercussions from other states. Like, for example, the extradition powers are in that treaty, and if a state doesn't extradite, one state demands an extradition from another state, the other state refuses, there's nothing that state can do. There's nothing Congress can do about it either. So he said, this is something that's not enforceable because there's no enumerated power. Prigg versus Pennsylvania is an opinion by Justice Story, Joseph Story, very respected judge, and he upholds the constitutionality of the Fugitive Slave Act. And he does so by doing something that's really very modern. It's sort of like a harbinger of the New Deal court. And he adopts a very capacious reading of what's called the Necessary and Proper Clause. And he says which says that Congress shall have power to make all laws which shall be necessary or proper to carry into execution its foregoing powers or any other powers it has under the Constitution. And that's fine. That's what the clause says. But then he says, if the Constitution creates a right, then Congress has the power to enforce that right. And he says the Fugitive Slave Clause created a right, giving Congress the power to do so. Well, I think that's a huge stretch. Huge stretch. He was prepared to do so for whatever reason. But I think Chase's argument is actually the stronger of the two arguments. But this is an argument about how, one of the lessons of this is today we're told that having broad national power is necessary in order to achieve all good things, and that states' rights are bad and they lead to evil things. But what was happening in Prig was northern states were passing personal liberty laws, which ensured that free blacks in their citizens could not be kidnapped by people who claimed that they were actually slaves and then taken into slavery. And so there had to be a jury trial, there had to be procedures followed. The states put into effect these laws. In Prig, the court said those laws were unconstitutional. Those state protective of free blacks laws were unconstitutional because the national power, under the Necessary and Proper Clause, trumps state power. And that's a great example of how national power can lead to really terrible results. It doesn't always lead to good results.
Yeah, and it does portend the entire progressive top-down design of big government as we know it today.
Right. There are two cases that we talk a lot about that do that way before the New Deal. And so the New Dealers can at least claim they weren't the first ones, and they weren't even the worst offenders. Prig versus Pennsylvania about slavery, and then there's the legal tender cases about whether Congress can make you take paper money instead of gold if your contract called for gold. And the court held yes, and they had an even more capacious reading of congressional power than the court did in Prig. But those are the two harbingers of what later is to come in the New Deal. The New Deal court, as for all its excesses, was actually more constrained in its rhetoric than either the New Deal court than the legal tender cases were, or even the Justice Story was.
Yeah. Okay, so this is one I think people will recognize: Dred Scott versus Sanford, 1857.
Yes. Well, Dred Scott is the preeminent anti-canonical case. It's the case that everybody agrees was terrible. On the other hand, today, and we'll talk more about this in the context of slavery, there's a lot of people who think that the Constitution was a pro-slavery document, and at least it was until the 13th and 14th Amendment were enacted, and therefore, if they're right, then it's not clear why Dred Scott is really so terrible, because if they're right, the Supreme Court is just following a bad Constitution, but it's not up to the Supreme Court to change the Constitution. So Dred Scott is only terrible and awful if, in fact, the court was going beyond the original Constitution, which would mean the original Constitution maybe was better than it's given credit for. So either the Constitution's right and the court's wrong, or the Constitution's wrong and the court is right, but you can't have it both ways. So this is a case, in my view, the court was wrong. And it isn't just my view, it was the view of Frederick Douglass and a bunch of other folks, including Abraham Lincoln. And we have a lot and we talk about what Douglass argued. And in our view, Dred Scott was wrong on a number of different grounds, and that's why we talk about it. It is used as an argument today by each side of our political divide against the other. So, for example, Justice Taney claims to be basing his opinion on something like originalism, only not original public meaning, but he's talking about the intentions of the framers. And one of the key parts of his argument is that the Southern states would never have agreed to a constitution in which someone like Dred Scott could be considered a citizen of the United States, able to sue in federal court. This actually goes back to the earlier discussion of Chisolm. What's at issue in Dred Scott is whether Dred Scott could be considered, if he was a free person, could be considered a citizen, and thereby he could sue in federal court under a diversity of citizenship clause, which says a citizen of one state can sue a citizen of another state. And the issue is, could he be a citizen? And Taney says, no, he isn't a citizen. He could never be a citizen because the original Southern states would never have agreed to a compact in which somebody like Dred Scott would be a citizen. Why? Because if he was, he could go around the country and exercise these fundamental privileges or immunities, like the right to assemble and to speak freely on all subjects, and the right to keep and carry arms wherever he went. If he was a citizen of the United States, he'd have those rights when traveling in other states. We know they'd never agree to that, therefore he couldn't be a citizen. So this is used as an argument against originalism by non-originalists. See, Dred Scott is an originalistic opinion. Well, I don't agree with that, in part because I think it's original public meaning originalism that governs, and it's not the dirty intentions of the founders that matters. It's what they wrote. That's a separate subject. It's also used by the right against the left because in another portion of the opinion, which there's no reason why the 20 actually had to reach this, because having found no jurisdiction, he should have just let it go at that. But he still goes beyond that and says that the Missouri Compromise, which basically allowed Congress to say that certain territories could be free and other territories would be slave. The Missouri Compromise was unconstitutional. Why? He said because it violated the Fifth Amendment's protection against the due process of law, which says that no person shall be deprived of life, liberty, or property without due process of law. The Fifth Amendment applies to the federal government. The federal government's running the territories, and the slaveholders are being deprived of their property and slaves, contrary to the due process of law. And this is then used by conservatives against progressives, saying, here's your earliest example of substantive due process. The due process clause is being distorted to protect substantive rights, and therefore substantive due process has a tainted history. So one side uses it to say substantive due process has a tainted history. The other side uses it to say originalism has a tainted history. Why? Because it's in the anti-canon, and you don't want your theory to be associated with an evil, terrible case.
It's a bad story.
It's a bad story.
It's a bad story.
It's a villain.
Which, of course, this debate leads right up to the history of the 13th and 14th Amendments, which is Chapter 27, and there's a bunch of different cases that you deal with here.
Right. So here's the thing. When we talk about the Constitution today, and we hear a lot of talk about our slavery past and the fact that the Constitution ratified or endorsed slavery, which is something that I think is a claim that needs to be qualified a lot. I tend to agree with Frederick Douglass and Lysander Spooner. And by the way, Douglass was convinced of this position by Lysander Spooner.
I didn't know that.
Yeah, he credited Spooner and William Goodell and one other figure who was actually kind of a guy behind the two of those guys. He attributed his conversion from the Garrisonian view that the Constitution was a covenant with death and an agreement with hell because it sanctioned slavery, to this view that the Constitution, if not anti-slavery, it was not pro-slavery either. And he said it was because of these three men that I changed my mind and went from Garrison to Spooner, essentially.
Yeah.
So I agree with them about the Constitution not being pro-slavery, although it allowed for slavery. Essentially, what ultimately happened is that folks like Salmon Chase, who took sort of an in-between position, said, and Douglass agreed with Chase too, said, look, the Constitution is not pro-slavery, but Congress does not have the power to abolish slavery in the states in which it currently exists. It has the power to abolish slavery in the District of Columbia, which they denied because of the Fifth Amendment. It has power to deny slavery in the territories, which the Supreme Court in Dred Scott said it didn't. They disagreed with Dred Scott about that, but it doesn't have power to end slavery in the states. That, they said, required a constitutional amendment because Congress does not have unlimited powers, and so the 13th Amendment gets passed after the Emancipation Proclamation because it's not clear what the constitutional authority for that is, and they wanted to make sure Congress had the authority. They gave them a new enumerated power. They passed that amendment, and then when that amendment got evaded by the South and by the racists in the South, they had to pass the 14th Amendment to try to amp up their powers to go after the people that were abusing the rights of the freedmen in the South. So the point I like to make is that when we defend the Constitution today as being legitimate, we are not defending the original Constitution. I don't have to defend the original Constitution, and I have mixed feelings about the original Constitution because of slavery, and also because of the secondary subordinate status of women. But we get to defend the Constitution as amended, and the Constitution as amended specifically did away with that defect in the original Constitution, thereby making it a defensible Constitution.
I think I keep latching on to that radical kernel that it's not even started with the Constitution, but it started with a lot of the philosophy that was embraced by the founders, that the individual comes first. And it strikes me that was a very radical and undeniable concept that forced us eventually to deal with slavery and all of the other defects in
Yes.
the original document.
And there's a lot of stuff coming out now about this in response to the 1612 project or whatever the name of that project is. There's stuff coming out now which is really, really interesting and good. And it's actually based on scholarship that we've known about for 40, 50 years. And that is that the Declaration of Independence was a critical accomplishment, a stepping stone towards the eventual elimination of slavery. That prior to that, slavery was prevalent throughout the entire world. England had a court ruling, the Somerset case, that had abolished slavery in England, but England did nothing about the slaves they held in the colonies, particularly in the Caribbean islands. Those are still up and running. And it was the Declaration of Independence that, actually the year before the Declaration of Independence, the first anti-slavery meeting that had been held in the world of an anti-slavery society was held in Philadelphia. It was Quakers that were doing it. And then after the Declaration was enacted, was the beginning of the end of slavery. And because it was quite obvious to everyone, including the slaveholders in Virginia and elsewhere, who wrote it, that slavery was incompatible with the principles of the Declaration. What to do about it was a secondary question. The first question is it compatible? No, it's unjust. It's not compatible. What do we do about it? Well, now we have to talk about that because there's issues. But it was the beginning of the fight to end slavery. That fight against slavery didn't start anywhere other than here. It started here, and it's not entirely clear that Britain, if we hadn't entered into this Constitution, which allowed for free states in the North and to get going, it's not entirely clear what Britain would have done to its slaves in the South, in the Caribbean islands.
I feel like in correspondence that maybe wasn't public at the time, but both Madison and Jefferson were well aware of the implications of their radically individualist philosophy and how slavery was a contradiction.
They were completely aware of this, and in fact, it was so obvious that into the early 19th century, eventually pro-slavery, when pro-slavery advocates started actually developing a pro-slavery ideology, which didn't really exist at the time of the founding exactly, they had to dismiss the Declaration, which they called a farrago of nonsense.
Yeah.
Because it was obvious that all men were not created equal to them. And so therefore they repudiated the Declaration. They didn't say, they didn't do what Tawney said is, we must interpret it in light of their intentions. What Tawney says in Dred Scott is, if we read those words today, we would know it applied to everybody. But back then it didn't apply to everybody. Well, that's wrong. That's one reason why he's so wrong. It did apply to everybody back then too. Yeah. Southerners eventually, they didn't do that. They basically repudiated it altogether. They said, it's ridiculous. Let's get rid of it.
Yeah. So we're sort of getting to a broader debate now about not just individual rights, but the right to contract and the right to be economically free as well. We're jumping to Chapter 28, the Privileges or Immunities Clause, and it starts with the Slaughterhouse Cases of 1873.
Right. Well, you see, the right to be for economic liberty grows out of the slavery question, because what is the slavery system? It's an economic system. And what is it based on? It's based on the lack of economic liberty of enslaved people. Enslaved people lose their right to hold property. They lose their right to enter into contracts. They lose their right to sue and be sued. They lose their right to a lot of personal security. They lose all their economic liberties. It's an economic. Why is that a surprise? It's an economic system. It's a system by which some people get to expropriate the labor of another group of people. And the free labor movement, which is the philosophy that underlied the anti-slavery ideology that grew up in response to the pro-slavery ideology, is that each person owns their own labor. That's what John Locke said in Two Treatises of Government. He says our property rights begin with ourselves. Everybody has a property in themselves, and have a right to exchange that for money or other things. So free labor is part of that. And after the 14th Amendment was enacted, one of the questions that arose was, well, who gets to take advantage of this freedom of contract, freedom of labor, right of private property under the 14th Amendment, which is now going to protect these things. And 5 years after the 14th Amendment is enacted, in a case called the Slaughterhouse Cases, which is an interesting case because is it in the canon or not? It's a case that most all law professors of every political stripe disagree with, and yet the Supreme Court continues to uphold it. And in that case, the Slaughterhouse Cases, it was some white butchers in Louisiana that were said that a monopoly slaughterhouse law that was passed as a public health and safety measure interfered with their freedom of contract and their right to pursue a lawful occupation of being a butcher. Because the law said you couldn't butcher now on your own premises. You had to go all the way to the monopoly slaughterhouse, pay them a fee, and butcher over there. It's a very long, complicated story. I gave a lecture about it in the Supreme Court a couple of years ago. But we simplify it in this book.
By the way, it's funny that not just this, in another case, it's based in Louisiana.
So many cases have come out of Louisiana. Plessy versus Ferguson is out of Louisiana. There's the civil rights cases are out. The Cruikshank case, which had to do with the massacre of African Americans. Louisiana has been a hotbed of constitutional cases, and all based on bad behavior.
Yeah.
Anyway, the issue was whether the 14th Amendment protects economic liberties of these white butchers, and the Supreme Court, 5 years after the 14th Amendment was enacted, said no, it does not. And then the day after they decided that, they decided the Bradwell case, which is also we do a video on. And in the Bradwell case, it was whether Myra Bradwell, a woman, could be denied the right to practice law in Illinois because she was a woman. And so the day after the Supreme Court says, well, there is no right to pursue a lawful occupation protected, that they said the right to pursue a lawful occupation is not a privilege or immunity of citizenship protected by the 14th Amendment. The next day, they said, and if we're right about what we said yesterday, Myra Bradwell can't sue to practice law because there is no right to pursue a lawful occupation.
Yeah.
So she loses out, and women lose out from this discrimination because the Supreme Court says we are not going to protect economic liberties of people. We might protect the liberties of freed blacks because that's what the amendment was aimed at, but not anybody else. Now, there are dissenters in the Slaughterhouse case, including Salmon Chase, who's the Chief Justice, but 3 others wrote opinions. Salmon Chase is very ill at this point and cannot write an opinion. So he joins. It's a 5-4 decision, and they say, oh, no, it does pursue a right to lawful occupation. And that case should come out the other way. I think, and my co-author Josh and I think, that the dissenters have the strongest argument here. But then what about the Bradwell case? What happens the next day? Well, 3 of the dissenters go over and join the majority, and they say, oh, we think there's a right, but it's not being violated here because women are different, and therefore it's okay to treat women differently because they have different spheres, they have different constructions, and their places in the home, and under the laws of coverture, they don't have a legal identity, so they can't be lawyers, blah, 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 blah,
This
blah.
is where the quote about being delicate.
Yes.
Yes.
Right. So that's Justice Bradley.
They haven't met my wife, by the way. She's...
Well, I've met your wife.
Yes. Delicate is not necessarily a word I would use.
Should punch you out for saying that.
Yeah. She may still.
Yeah. So, so the 3 dissenters, they say because women are different, there is such a right, but this law doesn't violate it. There is one dissenter, Salmon Chase, the defender of runaway slaves, the successor to Roger Taney. He dissents in this case, and he's too ill to write an opinion. He dies 3 weeks after the decision is announced. But he does have an interesting line in the Supreme Court reports, which I think it's unique. I've never seen it again. And that is, it says, the Chief Justice dissents from the decision and all opinions in the case, which means he not only dissents from the majority, he dissents from the concurring opinions. What they said about women, he dissents from that too, because he thinks the 14th Amendment, A, there's a right, and B, this violates that right. And women do deserve to be protected from unreasonable discrimination that's not founded based on the facts.
Lochner versus New York, 1905.
Well, this is a case that if you teach constitutional law and you teach it responsibly, you have to tell your students that this is a case that's in the anti-canon. This is a case that people think on both sides of the political spectrum was wrongly decided, and it's not only wrong, it's terrible. It's very, very bad. And it's very, very bad for 2 reasons. One is because it's substantive due process. We heard about that with Dred Scott. It's using the due process clause to say you have a substantive right to liberty. And this law in New York, which was a law that limited the hours that bake shop employees could work to 60 hours a week, that this law, the court held this law violated their liberty of contract to enter. The bakers and the bake shop employees should have a right to contract. And that elevated this right under the due process clause, which is substantive due process, and it's bad. It's very, very bad because it was elevating the wrong right and being protected, and it was protecting it under substantive due process. So it's considered bad, and that's considered bad by people on the right. People on the left used to think it was very, very bad. Now they only think it's very bad because they like substantive due process now. So that can't be the problem. The problem isn't that they were using substantive due process. The problem is they were using substantive due process in favor of the wrong right. So it's only very bad. It's not very, very bad. And so you have to teach it this way. Now, I have to confess, Matt, I actually think this is one of my favorite opinions ever written by the Supreme Court. I think it's very, very good for lots of reasons. It's one of my favorite opinions. And it's actually reading this case in constitutional law as a law student and then reading the reaction to it by subsequent courts is what caused me to turn off of constitutional law altogether and become a criminal prosecutor and then a contracts professor, because I thought it was a great case, and then I turned the page of the casebook and I'm told not only is it wrong, it's so terrible that you should not emulate it. It's in the anti-canon. But I think, with academic freedom, I'm entitled to say I like this case a lot, and in our video we do explain why we think it's good. But we have to first inform you, and responsibly as teachers, that you're supposed to think it's bad.
Okay, let's wrap it up with this, because we could go on, and this is really fascinating stuff.
Well, the videos last 11 hours, so we could go on for 11 hours.
Yeah, we could just do a marathon,
right?
But we'd have to bring whiskey to the table at that point. But let's wrap up with Chapter 32, Economic Liberty in the Progressive Era. And it starts with Muller versus Oregon in 1908.
These are cases that are still in the Lochner mold. So they're protecting economic liberty. What we really then, I think, basically need to do is to get to the New Deal, where they reject this whole idea. Mm-hmm. And that's essentially the next phase of the story. So first, they start protecting these liberties, but they start invalidating progressive laws. And that's where you start getting this Brandeis brief. This is the Muller case that you're mentioning. So the pushback comes. The court is basically saying in Lochner, they're saying, look, this is supposed to be a health law. It's passed under the rubric of being a health law. We don't see a real health law benefit going on here. This is part of a larger statute called the Bake Shop Act, which the court said was perfectly constitutional because it really was a health law. Regulated ceiling height, ventilation, whether animals could be in the premises, whether you could sleep there, where the washroom should be. It was a very elaborate health and safety law, which the court said is perfectly fine. The Lochner court said this. It's only this maximum hours law that got put in there at the behest of the labor unions that they thought was not really a health law and not justified as a health law. So in the next case involving the minimum wage law or a maximum hours law for women, not for bakers, but for women, Louis Brandeis, the hero of the progressives, who ends up going on the Supreme Court, very activist guy, he files what's called a brief, which was now called a Brandeis brief, that doesn't consist of cases and doctrines and precedents. It consists of snippets of social science and supposedly biological science. 80 turgid pages of pseudoscience, including something you mentioned before we went on.
It was about women and how their blood was thinner than men, therefore they couldn't possibly do the same things.
Right. They needed to, in other words, he said, just like the dissenters in Bradwell, in Slaughterhouse, who thought that this law was reasonably applied to women because women were different, he provided scientific evidence that women were different. And therefore, the legislature was right to limit the working hours of women, even if they didn't limit the working hours of men. And because of all the different weaknesses and frailties of women, and they were subject to indisposition, and they could do delicate work, but they had a hard time if they were standing up, and plus they might get pregnant, and the future of the human race depends on having healthy pregnancies, and this was bad for society. So it was all this all this science, and the court buys it. The court says, we accept this. the Lochner court, the post-Lochner court says, okay, now we've heard evidence. We'll accept it really is a health and safety law. So they uphold it. Great, hurrah. Progressive legislation has been upheld. Ironically, Brandeis is still held up as a big hero. And Brandeis briefs are held up as a big innovation. And yet it was all about it was all about the inferiority of women.
Yeah.
And it turns out...
And this is in the context of the Wilsonian era and scientism and
yes.
even eugenics, right?
Yeah, of course. And we talk about Buck v. Bell. Another case, we give a whole video about Carrie Buck and how she was railroaded and sterilized under a eugenics law that was a progressive champion. Although, truthfully, people on both sides, eugenics was the science of the day, and lots of people, regardless of ideology, believed in eugenics. But progressives were really, really into eugenics in a big way.
Yeah.
So eventually, this era comes to an end of protecting economic liberties in part because of things like Brandeis. But Brandeis gets on the court, and what's the first thing he does? He eliminates the need to prove that these laws are rational, and he switched the burden of proof to the challengers of laws that say, well, we're going to presume laws are okay unless you can prove they're irrational. So you have to file a Brandeis brief to challenge the law, not just one to defend the law like I did. And by switching the presumption from the one favoring the liberty of the individual sovereign, going back to the beginning, to favoring the legislature over the sovereign individual, now the burden is on the individual to prove that a law is unconstitutional. And eventually, as we tell it, by 1955, the Warren Court makes that burden irrebuttable, that presumption irrebuttable. It's a burden you cannot win unless you can establish you have a fundamental right of some kind. So that is the beginning of the end of the protection of economic liberty in this country. And at the moment, it's still relatively unprotected. We don't agree with this, but we teach it. We tell the story the way they are. These stories have heroes, they have villains. We don't like all these cases, but we tell the cases that you need to know to understand what the Supreme Court has been doing with the Constitution for over 200 years.
Which is why everybody needs to read this book to understand the context and how we lost that original notion of individual freedom and sovereignty. And let's talk about this.
One story at a time.
Yeah, one story at a time. And I have a former career as a grassroots organizer, and we would spend every day, all day, talking about the rule of law and defending the Constitution, because I think every citizen needs to understand this story.
I agree, and that's why we wrote it for the general public, the videos for the general public. We originally did the videos for students who used our casebook, and then we got in the middle of the video project, and we thought these videos are just too important and too accessible to be limited to law students who are using our casebook. And so we created this book, this separate book, as a vehicle by which everyone could get access to these videos, because we thought the American public in general, and students of all varieties down to high school level in particular, need to know these stories. Then they will understand what the Supreme Court is doing.
Yeah, so you think that this could be used for homeschooling, it could be used to prepare if you want to pursue a career in the law, but if you also just want to be a good citizen. You want to understand the rules of the game.
If you go on Amazon and you read the reviews by people who have read the book and who have watched the videos, you will see what they say about how accessible these videos are. And I think it would make a fantastic homeschool course where the students would read a chapter, a 3-page chapter, then watch a 5 to 15-minute videos. The videos are all really small, and then talk about it. And you go through one chapter a day for 63 days, and you will understand more about the Constitution than many lawyers do who don't know these stories, don't know all these stories.
So I was many years ago a wannabe academic, and I remember the pricing of academic books, and they were prohibitive, and I assume there was some sort of cartel sort of mentality with that. But you managed to get a market price on this.
Yes.
What is it, $29.95?
$29.95 for the paper. I have a case book. If you wanted to buy our casebook, the casebook costs depending on which version you get, between $200 and $350.
Which is typical academic pricing.
Yeah, partly because the market is so small, they have to make their money back on very, very few sales.
Yeah.
But this is a book for the mass market, so the paperback is $29.95. That gives you the book and access to all 63 videos, but there's a code inside here. Let me show, because actually some people who are not tech-friendly don't realize that Here's where the code is.
I buy a lot of lottery tickets, so I figured
and you
it
scratch
out.
off
Yep.
the code carefully so you don't scratch the number off at the same time you're scratching some of the older folks just scratch the number right off. They must have never bought a lottery ticket. And that's your code. You go online, you get access to all the videos. That's $29.95. Oh, Amazon sells it for a little bit less. You can buy an ebook from Amazon or an ebook from the publisher at $24.95, and that gets you a code for the videos, or videos only from the publisher at $19.95. If you go to conlaw.us, you will see 30-second previews of all the videos, and it will give you links to buy it in either of the three formats: paperback, ebook, or videos only.
Cool. So we'll post all that stuff on social media so people can check it out, because having done about half of the coursework, I think it's one of the best things I've ever consumed on constitutional case law. It's good stuff. You guys did a great job.
I appreciate that, Matt. It means a lot.
And thanks for doing this. This has been awesome.
Well, now I got to go back to my office and finish writing my exam.
Yes, you do. Thank you. Thanks for watching Kibbe on Liberty. By now, you know this is the most important event of your week. So make sure you subscribe on YouTube. Click the little bell so you get notifications. Kibbe on Liberty, mostly honest conversations with mostly interesting people.